Okay, great. So I'm going to take this again. Good morning, good afternoon, good evening from wherever you're watching us all around the world. You're welcome to another interesting synergy series. And we are back bigger and better. And thank you so much, Honourable Justice Harriman, for taking time out of your very busy schedule to be with us. I am super excited to have you here with us. Thank you so much, my Lord. So usually we take about 5 minutes to allow people come in, but this is already 5:01 and we have 18 people in here with us. So what I'll just do for another 3 minutes is to give a brief oversight of what the Synergy series is all about. And hopefully in another 3 minutes, we have probably more people and then we get right into it. So first of all, I'm super excited to be here again. We took a break to go back to the drawing board to come up with other initiatives. Now, what you will be seeing over the next couple of months about the Synergy series is that apart from focusing on sitting High Court justices, and we have Honourable Justice Roli Harriman here with us, we would also be focusing more on the end users. So what we want to do now is to get into the mindset of the end users from various industries to know what their thoughts on mediation is and find out from them why they don't embrace mediation as much as they should. So thank you all for tuning in. And before we get right into it, I'm going to just read out the bio of our guest for today. Now, the Honorable Justice Roli Harriman is a judge of the High Court of Delta. She is also an ADR judge and the vice chair of the governing council of the Delta State Multi-door Courthouse. She's a CEDR UK accredited mediator, holds a diploma in International Commercial Arbitration and a fellow of the Chartered Institute of Arbitrators UK. She's also a Harvard Law School trained negotiator and holds a diploma in advanced negotiation from CEDR UK. She has had varied experience as a mediator in Nigeria and in the United Kingdom and is a great advocate of forging peace worldwide through mediation. She served on the panel of neutrals of the multi-door courthouses at the Abuja and Lagos High Courts and was chairman of the National Committee on the Replication of Multi-door Courthouses in Nigeria between 2004 and 2008. Justice Harriman also served as chair of session on dispute resolution at the African Bar Conference in Port Harcourt, Nigeria 2017 and a speaker at the ICC 2018. She served on the EXCO of the NBA Lagos in different capacities for many years. She also served as the Secretary Legal Education Review Committee of the Council of Legal Education from 2006 to 2008. One of the major changes was to introduce the teaching of ADR mechanisms at the Nigerian Law School. The Honourable Justice Roli Harriman has a master's degree in law in corporate and commercial law from the University of London. She was called to the Nigerian bar in 1984. She started her legal career with Chief Gani Faromi and has practiced law in all levels of court in Nigeria. She taught commercial law, ADR, and professional ethics for over 5 years at the Nigerian Law School. Ladies and gentlemen, I present Honourable Justice Roli Harriman to you. Can we all just give her a virtual hand clap? Thank you so much. Milord, can you hear us?
Yes, I can.
Okay, thank you so much, Milord. So for the benefit of those tuning in, this Synergy series is unscripted. And what we try to do is to connect with the essence of the guests we have on the hot seat. Most of our questions are unscripted. We ask questions at the inspiration of light. So if at any point in time you have any feedback or comment or even question, kindly please indicate in the chat room. And if you feel you need to ask Milord questions, indicate by raising your virtual hand. But please, let's keep it brief so that we can maximize the time we have here today. It's going to be a super session, for want of a better way to put it. So, Milord, let's kick the ball rolling. So, Milord, can we first of all start off by you please taking us through your journey on how you first of all became a lawyer and how you got to the bench and how you found out about mediation? Yes, because like I always say, the journey is as important as the destination. How did you find out about mediation? Because mediation for a lot of people is not a word that just comes up from anywhere. How did you find out about mediation, my lord? Over to you.
Okay. If you want me to start from when I decided to become a lawyer, that would be brief but boring. I've always wanted to be a lawyer since, I believe, since when I was 12. And along the way, I met a few people who encouraged me to do that. And by the time I was leaving law school in 1984, working with the banks was a very popular incentive after leaving law school. Fortunately, again, I met a family friend who advised me not to go to the bank. All my friends were looking for bank jobs because the pay was right at that time. He advised me not to go to the bank, but to find an opportunity to gain experience, because he said, that's what makes you a lawyer. Fortunately, again, I went for an interview at Ghani FMA's chambers and I was recruited. On the day he employed me, he told me there are 3 things he would not want me to do, to think about, or he would want me to do. And these 3 things are work, number 1, number 2, work, number 3, work. And he's, of course, because I was a young guy, he said, forget about boyfriends. I will not tolerate that whilst you are here. Anyway, that was my journey to Ghani FMA's chambers, where I worked for over 4 years. As you would know, Ghani FMA's chambers was based so mostly on litigation. The matters we had were like 99.9% litigation. So as you would expect, like my foundation was litigation based. Even my youth court was litigation based. So I was surprised. That leads me now to how I heard about mediation. Of course, after Ghani FMA, I also set up my own law practice and was practicing. After some years, I also set up continuing legal education, courses that lawyers do after leaving law school. So looking for a venue to hire to train these lawyers took me to the Lagos Multi-door Courthouse. And I was referred to somebody who was in charge of the rooms that could be hired. So instead of negotiating how much I would pay for those rooms, this gentleman started talking to me about alternative to litigation. And I found it very interesting because, of course, ADRO was not taught when I was in the law school. I found it very interesting. Interesting in the sense that the person who was telling me about mediation was an engineer. You may know him, Engineer Shegun Ogunyanwo. So when I left the multi-door courthouse that day, I was thinking about it. And I talked to my colleagues. I was also teaching at the law school at that time. And I spoke to my colleagues, what's happening? I think I just joined the law school. Why are we not introducing this mediation ADR to students? So in any case, Shegun convinced me to take a course, and that's how I got the CEDR qualification. And I just fell in love with that area. Because of my love for conflict-free society. So coming from a litigation-based foundation and then to mediation, it was a switch, but I regarded it as the day I was born again, the day I saw the light. So think about alternative ways. Instead of protracted conflicts, there are other ways to resolve disputes than litigation. So that's how I started developing myself, went to Harvard, went to Oxford, and I learned a lot about mediation and arbitration and all of that. And here we are. Of course, I introduced it into the law school. Also, when I became a judge, I insisted that we must have a multi-door courthouse, we must train judges to keep on referring matters for settlement out of court. Most of these laws about settlement out of court, they were already there, just that people were not advanced to it. But I'm glad to say that the young lawyers now all were trained trained in ADR. So that's my journey so far. And I'm enjoying it.
Impressive, my lord. Very quickly, my lord, I would like to acknowledge the presence of some of the distinguished guests we have here with us. First, we have Honourable Justice Onome Marshall Umukoro. That's the judge of the High Court of Delta State. Thank you so much, my lord, for tuning in. Truly honored to have you here with us. Thank you so much, Milord. Then, yes. Then we also have, Milord, do you want to say a word or two before I move on? Milord, Honourable Justice Onome Marshall Omokoro. Okay, I think.
Can you hear me?
Yes, we can hear you, my lord.
My Lord Harriman, very good to see you.
But I can't see you.
I'm having a problem with my video. I don't understand.
Okay, that's all right.
Good to see you, and I'm happy to be here to learn from my Lord also, my very senior learned brother. And I welcome everybody here. Thank you very much.
Yeah, thank you so much, my lord. Truly appreciate this. Thank you. Yeah, and we also have the chairman of the Incorporated Trustees of the Attorney Mediators Association in the person of Mr. Yomi Okunu. Thank you so much, sir, for tuning in as always. And then we also have distinguished directors of some multi-door courthouses. Thank you for tuning in too. We truly appreciate this. So, Milord, now we're going to get right into it because we have you on the hot seat. We're not going to be asking all those regular questions about mediation being voluntary and all of that. So we're going to get into the thick of it. So, Milord, in your opinion, what do you think is responsible for conflicts generally, using Nigeria as a yardstick for answering this question? Because I think that should be the foundation of everything.
Sorry. Can you repeat the question? You got cut off for a second.
Okay, I said, my lord, I'm going to start off by asking this question as a foundation to every other question. In your opinion, what do you think is responsible for conflicts in Nigeria? Conflicts generally in Nigeria, what do you think is responsible for it as a sitting judge?
My lord.
I don't think my lord heard me. Milord, did you hear my question?
I'm sorry, I didn't get that.
Okay, I'm going to ask it again. I said, in your opinion, Milord, what do you think is responsible for conflicts in Nigeria? Did you get that now? What is responsible for conflicts in Nigeria? Yes, Milord.
Yes, thank you very much. I got that now. I mean, that may be my personal opinion, but I would think generally conflicts are generated because of lack of good communication skills, both oral and non-verbal communication. As you can see, we all didn't grow up in the same homes. We had different backgrounds. So, but as we are growing up, this lack of understanding of communication, talking about how you feel, understanding how you feel, exhibiting negative non-verbal communication. These things bring a lot of misunderstanding, which leads to conflict. And it is really, and then that feeling of being neglected, of being used. So all those feelings all boil down to lack of good communication skills. So communication skills is key. Lack of it is the breeding ground for conflicts. That is just my opinion.
Interesting. Now, Milord, do you think the courts are best suited for conflict resolution? Because you wear two hats.
Oh, yes, they are, of course, because the alternative would be to carry cutlasses and guns and so on. So the courts are well suited. The only danger is that in a court of law, where litigation just takes the uppermost part, at the end of the day, one person loses. And the conflict continues. The legal rights may have been established, but the conflicts continue. So I cannot say that litigation is not a good thing. It is to a large extent. It can stop further conflict. It can stop wars. It can stop people carrying up arms against themselves. But at the end of the day, because one person loses, and if that person has this feeling that I didn't get justice, that is why you see appeals to the Supreme Court, because at the lower court, the person thinks, no, I don't get justice. It is because the judge is a woman. It is because the judge is from Delta. It's because the judge is from... So there's so many reasons. And this is fueled too by their lawyers who give them all kinds of stories. So they feel they've not gotten justice. But I cannot say that really, the lower courts are 100% right. That's why we have established a higher court. So it's good to appeal, but it is that feeling of I have not gotten justice in the lower court that makes people keep on appealing and appealing all the way to the Supreme Court. So at the end of the day, a lot of money is lost, a lot of conflicts continue to multiply, and here we are today.
Interesting. Okay, Miller, before I proceed, I would also like to acknowledge the presence of Rotimi Ogunwesho, SAN. Rotimi Ogunwesho, SAN used to be my former boss at my former workplace, and is also instrumental to who I am today as a mediator. Malga, thank you so much for tuning in, Mr. Ogunwesho. Yes, could you please unmute and just say a word or two?
Thank you. It's nice listening to you and listening to my Lord. The issue of settlement, mediation is something we should encourage in our legal practice, because by and large, if we pursue that path, there will be more confidence in the justice system. Cases have been in court for ages. Sometimes I get embarrassed, like when my matter does not go on. Somebody just told me, a colleague a few weeks ago, that the Supreme Court has become a cemetery for cases. They bury it. So, and when client starts feeling like that, it appears we are far from being whole. Thank you very much. I'm listening very attentively to my Lord, and I tend to agree with everything she has said. Thank you very much.
Yeah, thank you so much, Malga. Thank you so much. Okay, my Lord, Mr. Ogunwesho has one word actually set up a team now. Courts in Nigeria, a cemetery for cases to be or not to be. What are your thoughts on that, my Lord?
To be or not to be, are you saying whether I believe in that phrase?
Yes,
I don't know what that means.
I coined it. And it's interesting. He actually started off on this note, because I was going to actually ask a question, but I'm going to build it around that framework, my Lord. First of all, my Lord, and this is my own personal thought. I struggle with the concept of a judge that embraces mediation. My Lord, we're talking about a judge, unquestionable judge. Whatever is final. A judge has power. So if a judge is now encouraging settlement, I'm looking at a judge on one part, and I'm looking at mediation on another part. I understand why parties need to settle, my Lord, because, okay, fine, they need to move on. I understand why lawyers have to embrace settlement, because it helps them close their cases faster. But when a judge who has the power to say, yeah, of course, there might be one or two checks and balances here and there, but at the end of the day, you have power arrogated upon you, my Lord. So I don't understand why you should even believe in the concept of mediation for starters, my Lord. Those are my thoughts. I would like to hear what you have to say on it.
Yes, thank you very much. I think I'll start from the middle, where you said you understand lawyers embracing mediation. But that's the problem that we have. Do they actually embrace it? Because if a lawyer embraces mediation, your case will end quickly, and then you will lose some money. So I don't know whether the theory is correct that lawyers are happy about mediation. With regards to the judge, you see, if a judge has no personal interest, whether the case is fought to its logical conclusion, whether one person wins or loses, the only interest the judge has is that, for me, is that people should go home in peace, should live in peace, especially if they are related, they come from the same clan, they come from the same society, they are blood relation. It's very important that the conflict is not escalated by litigation. And many of our judges have been trained to think that way. Remember, although we have a minimum number of cases we need to deliver judgments on, I don't think that's the problem to encourage litigants to settle their matters out of court. The meager salary you are paid remains the same, whether or not people settle out of court. So you really don't have any, if you believe in a conflict-free society, then you would encourage it. And the laws are there. The High Court law is there, the rules of court are there, the Constitution is there, all to encourage you, to encourage others to settle their matters out of court. So it's not as if there is anything to lose. The judge does not lose anything if he encourages the parties to settle out of court, because your salary is stagnant, you know. So, and there are so many cases that won't settle anyway, so you have enough judgments to write. Sometimes judges are beefed by, you may have been encouraging them to settle, and then after you've taken all the evidence, at the point of adjourning for judgment, they now said, we would like to settle. I mean, that's fine, you know, but it's usually better to settle to try to settle at the beginning than at the end when the judge has taken all the, but I've never heard of any judge who will say, no, I'm not going to allow you to settle again just because I'm not ready to write a judgment. I doubt if there's any judge like that. So to put your question in its right perspective, litigants, if you educate them, and who educates them is the lawyers who have to educate litigants. And you know, by your rules, by lawyers' rules of professional conduct, you owe that litigant a duty to advise them that there are other ways of settling their disputes than litigation. And a breach of those duties will attract punishment under the Legal Practitioner Disciplinary Committee. So it is the lawyers who should encourage their clients. The judge will just assist in doing so. My experience has found that it is when the judge mentions, have you tried to settle? That's the first time the lawyer thinks about it. Some may not be happy with it when the judge mentions it, but that's the first time the lawyer addresses his mind to his own rules of professional ethics. So to say that lawyers embrace it, I'm still waiting for that day. Thank you. Fola, are you there?
Yes, my lord, I'm here. I can hear you, my lord. Hello, my lord, can you hear me?
Yes, I can hear you. I don't know if I was able to answer your question.
Yeah, my lord, can you hear me?
Yes, I can.
Okay. Well, I was actually going to get to that part. Maybe I should have actually said some lawyers. But before I proceed, we have a virtual hand up. So like I said, they're very short so that we can accommodate as many questions as we can. So Mr. Okechukwu, I will be unmuting you now. So please keep your question, feedback, or comment very short. Over to you. Okay, Mr. Ken, I've unmuted you. Can you accept? Okay. While he's still trying to figure that out. Now? So, okay, Hello? He has unmuted himself. Yes, okay, we can, Mr. Ken. Yes, we can.
Thank you very much. Thank you very much. I've not had words like this from a judge in a long time. She's one in a million. Her mind works like a parachute. The parachute works best when open. And I can see from her presentations that she keeps her mind open and is able to be born again, even using her own words, at the inspiration of light. If judges were like this, then ADR will, take a stronger route to replace litigation. Litigation is good, but it's not enough in the light of the day. Thank you, Justice Mrs. Harriman. I'm glad to be in this meeting today. What I want to say really is, in trying to make mediation popular, my thinking is, we are in an age where people find it difficult to change their mind easily and do what they don't see others do. We are in an age where, bandwagoning, social proofing. People do something because they see others do it. So they say, oh, if these guys, if this...
So, Mr. Ken, what's your question? What's your question, Mr. Ken?
My question is, well, thank you. I didn't really mean to put it in a question. I mean to acknowledge her presentations. And
okay then.
So my question in a way is, when will the legal system, begin a fundamental change to factor in this alternative route to justice? Because, like she said, it is after litigation that the dispute continues as a conflict. That's when people who have gone to court, one person has won, the other person has lost. That's when they call their families together and they say, hey, the children of this man, don't play with them at school. Don't talk about doing business or getting married to them because they took us to court and they took our piece of land and all that.
Okay then. Okay
Thank
then.
you.
Thank you so much, Mr. Ken. Okay, Milord, I don't know whether you got Mr. Ken's question.
I don't know, it was breaking up, but I think the main thing he was trying to ask was, when will the legal world do something to encourage ADR? Is that what?
Yes, that's the truth, yes, my lord. Yes, ma'am.
Shagu's hand is up.
Yes,
Don't
I'll take it. I'll take it. I will. I will as soon as I'm done with Mr. Ken. Okay.
Do you want me to comment on Ken's?
Yes, my lord. Yes, I want to comment on yes. Okay.
Yes, Ken, I think we are there already. There's provision for all of this. Like I said before, the first point is the legal practitioners, professional rules of ethics, rules of professional ethics. In that rule made by lawyers themselves, I think it's rule 49 or so, it says the lawyer is enjoined to advise his clients of ADR alternatives. In Rule 55, it says if any lawyer breaches any of these rules, he's liable to suspension or even struck off the role. There's punishment for it. But my experience has shown that this is not done. I would say that as a human being, I doubt if people enjoy conflict. They may be doing ego and bravado. Nobody enjoys conflict. Litigation involves you abandoning, because if you are sued or you want to sue, you must come to court to prove your case. Even as a defendant, you don't have a choice. You must come to court. You must abandon your business. You must abandon everything. You must come, whether you think you have a good case or not. So I doubt if litigants actually enjoy conflicts. Cases have lasted, on the average, cases last at least 17 years from the High Court all the way to the Supreme Court. Who can enjoy that kind of thing? It would be abnormal, except of course, the person has gone to court for his nuisance value and is being encouraged by the system to keep on propagating that nuisance value. But no human being, even lawyers, they don't enjoy it. You go to court and you wait from 9 a.m. to 2 p.m. to 3 p.m. You can't even go to the bathroom if the judge is sitting. You don't know when your case will be called. Nobody enjoys that. But I think the lacuna is training lawyers to know how they can key in, how they can make money from this aspect of legal practice. That is where the space is. We have not reached that stage. And maybe the NBA should take that up and organize conferences for us to decide. Like in my state, I encourage lawyers. I tell them, even if you are going to the multi-door courthouse, you need to charge for that. So if you are used to collecting appearance fee, you need to collect your appearance fee when you are going to the multi-door courthouse.
Milord, if I may respectfully interject, Milord, you have raised one fundamental issue, making money from mediation. Do you think that is where the issue is, Milord? Especially with the antagonistic nature of lawyers as far as mediation is concerned. Do you think it's because they don't understand how to make money from mediation? Do you think that is why they are antagonistic of it, or they just don't understand the concept of mediation as a sitting judge?
There are two reasons why they seem to be antagonistic. One is ignorance. They have no idea what mediation entails. They have no idea. And so because of that, they push it away. I don't want to be involved because I was not trained in law school on how to negotiate. I mean, lawyers who have passed in the last 15 years were taught, but of course they did not pay attention because it doesn't look so legalistic. A lawyer's role in ADRO, at least in mediation, is to use his negotiation skills and to get the best for your clients. But because we come out of law school, it depends on who you practice with when you leave law school. That part of the training on negotiation is easily thrown to the gutters. So it is ignorance or lack of knowledge on how ADRO works, lack of knowledge of their role in the mediation process. It makes them shy away from it. I recall that in some matters that we practically force in quotes that they should go to the multi-door courthouse, you will see the lawyers just run away because they don't want to be involved, because they don't know, and they don't want to know. That's the strange thing. We should learn to learn new things. We should love to learn new things, new ways of doing things. It's just like virtual hearing in court proceedings. Many lawyers are against it, and that is because they are afraid. We are using Zoom now. They are against it because they don't know how it works. They assume it's complicated. So they condemn it. They have no good thing to say about it. Same thing with ADRO. Because they have no idea how it works, or they don't know their role in the ADRO process, they shy away from it. If the client really wants to go, they just say, please go, I don't have time. So, and the second thing, money is also a major part, because many lawyers make money from appearance fee. You know, when you stand up in court and you spread your black gown and you shout and you cross-examine and you know, it's like watching DSTV. Like I always tell my security men, they, instead of taking care of security, they actually watch the witnesses giving evidence. It's enjoyable. And you see, in those days, you know, you still litigant, you'll be throwing money in the back pocket of the, you know, when you ask questions, the questions may look silly to the judge or to the other counsel, but the litigants, once you are shouting, your client is happy. So they like that drama. They're not thinking of the interest of their client. One thing, and why I say all this is I don't mean to disparage the role of lawyers in resolving disputes. I can tell you that most of the costs awarded, up to 95% of costs awarded against litigants is brought on by something that their lawyers did not do. And that thing they should have been done in chambers, not in the open court. Cost is awarded, the client continues to pay. I've had costs to say, you know they're sorry for your clients. I've had costs to say that. So money and lack of knowledge is one of the main reasons why we are still having this thing. You see, judges have moved. 15 years ago, judges were wondering, you will take our jurisdiction from us. But with training, most in the country, they have bought the idea. 15 years ago, no, once you say we want to settle, no, I don't have time, you must do your case today. But now, even at the point of judgment, judges encourage it. So where we should be focusing on now is the lawyers, because the lawyers are the closest to the clients. If they appreciate the disadvantages of litigation, they will be able to explain. I'm not saying they must settle out of court. All I ask is explore settlement. If you don't settle, you come back, no go transfer, you come back here and you make me decide your fate, when you can decide your fate in mediation. So
I'm sorry. Yes, sorry, Milord. Mr. Shegun, I'm going to take your question or comment. So, Milord, for those of us on the outside that don't know the inner workings of what happens in chambers, we hear there is this thing called returns that judges have to file every year, and that that's what we hear, and that if they settle, if cases are more settled, that it does not really go, that it does not really add to the I don't know what word to use for the judges. So most judges always tend to want cases to be set. They always want judgment on cases. So the more cases that are settled for judges, it doesn't really add to the returns they have to put in every year. I don't know. That's what we hear on the outside. So I don't know what your thoughts on this is. I don't know where you heard it before. What you have heard
happens on the inside is true, but the reasons you have given is not true. I doubt, and I do a lot of talking to judges, I doubt that any judge will insist that a case goes on if the parties want to explore settlement. I doubt it. Because there's a minimum number of judgments you need to produce for the NJC. There are very few judges who cannot do 3 times that. So 1 out of it doesn't make any difference. Except you are sick, you are able to meet the minimum requirement. So that's not a problem at all. I told you the only time we are human beings that one can grumble is when you've taken evidence for 3 years and at the end. For me personally, I don't mind. Even at the close of the case, I still say, please, you have time to still settle this matter out of. I still tell them. So I doubt if any judge will say, no, you must do the case. So, no, I mean, I doubt it. I doubt it.
Okay, Milord, yeah, I'll take Mr. Milord, I'm going to take Mr. Shegun's feedback and comments, but for those of us at the bar, let's just say that you're just you're a judge that is different. You have a different mindset and philosophy to mediation.
My Lord Onome is like that.
and Milord Onome is, but only only very few judges actually share the same sentiment. But let me just take Mr. Shegun's feedback. Mr. Shegun, I'm so sorry for putting you on mute for so long. Could you unmute yourself and let's take your feedback? Please keep it very short. Feedback, comment, or question. Thank you.
Mr. Fola Alade.
Yes, sir.
Thank you for the great job you are doing.
Thank you so much.
I appreciate you. I really do. Thank you. I want to pay special homage and respect to my Lord Honourable Justice Roli Harriman. Whatever I've become today, she's instrumental to it. She encouraged me to write my first book, The Effective Mediator. My Lord, you are a great judge. Your life epitomizes the 4 quotients: intelligence quotient, emotional quotient, social quotient, and adversity quotient. The history of the justice delivery system in Nigeria will not be complete without the mention of your intervention. Thank you, my Lord. Thank you for the great job you are doing in ADR. Mr. Fola, if you allow me, I'll add one other reason why lawyers are not interested in mediation. It is about the mediators themselves. There are some mediators who do not allow lawyers in mediation. Went to one of the centers in Enugu. I said, no, we don't allow lawyers in mediation. They compound things. And I told them, no. If you ask a lawyer to leave, as the lawyer steps out, the lawyer starts sending text messages. Do not accept anything without my consent. So from outside, they start dictating what happens inside. So we encourage mediators. When you have lawyers in mediation, appreciate their presence. I can see that both sides have their lawyers with them today. Thank you for coming. Thank you. Thank you. I appreciate you. And I look forward to working with you throughout the proceedings. So once you bring in lawyers in as partners, if there's deadlock in mediation, then you can call them together and tell them that if this case is not resolved, they're the ones that the parties will return to. If you don't mind, I'd like to pick your brains on how best to get this dispute resolved. Once the 2 lawyers talk to themselves and they agree, they find it very easy convincing their clients. For this honor of allowing me to speak, Mr. Fola, you are most appreciated. Thank you.
Thank you.
Thank you.
Thank you so much, Mr. Shegun. My Lord, Mr. Shegun has broken one table, the complex relationship between mediators and lawyers. You see, that table is a seminar discussion on its own. So I would like to hear your thoughts on this. When I was writing down some of the questions I was going to ask you, I deliberately left out that part because in the last 2 weeks, I've had some clients get in touch with me to tell me that, Mr. Alade, I just went for a session now and I was horrified. In fact, there was one a lawyer told me last week. He said his client did not want to settle and the mediator went ahead. and kept on insisting on settlement. That even when the client said he didn't want to settle, that he went ahead until the client walked out. In fact, what I had to do was to give the client the number of someone at the Lagos Multi-door Courthouse. I said, you know what, speak to this person. This should not be so. And there have been incidents of clients complaining about the conduct of mediators, especially how mediators see lawyers as adversaries. The moment they come into a session and they find that there's a lawyer there, they almost immediately get on the defensive. They don't see the lawyers as part of the process. Even as a mediator and the mediation advocate, I've had that kind of struggle too with mediators. In fact, there was a mediator that literally walked me out of a mediation session. I was horrified. Thankfully, there was a senior mediator that was passing. I just went to meet the senior mediator, and the senior mediator intervened. But of course, we could not settle. So I would like to hear your thoughts on this, on the complex relationship between lawyers and mediators. Thank you so much, my lord.
Unfortunately, I will have to agree with Segun in this area. And there are many reasons for that. That is the attitude of our mediators. I think there are so many problems associated with that. Lack of training. People believe because they are lawyers, they can be mediators. You need to, I mean, I was talking to magistrates and all of that at one point, trying to encourage them to refer cases. But halfway through the training, I discovered that the magistrates were wondering how they can be mediators themselves. I said, at the point I was talking to you, I've spent nothing less than £100,000 to train myself. It doesn't just happen like that. You don't say because you are a lawyer or a judicial officer, you can automatically be a mediator. It doesn't happen. So one of the problems that mediators have, mediators who practice here, is that there isn't enough training and retraining. It is like being a lawyer. When you get out of law school, you are a lawyer, but I doubt with the law school training, you really are able to prosecute a case. You need to learn from experience, Same way, another reason, apart from lack of training, is the fact that mediators rush. They want a settlement as quick as possible. And they have this in their head because of past experience that if a lawyer is involved, it will be more complicated. But as Segun said, remember that the clients, they believe in their lawyers more than you. So if you try to run down the lawyers and they go back to their lawyers, the lawyers tell them, no, you shouldn't have agreed on this. I should have gotten you a better deal. Sometimes the lawyers spoil it, so to say, because they were not involved, not because they don't think it's a good deal. So the mediators need to be trained, the lawyers need to be trained. So there should be no rush to settlement. We must allow people to air their views at the mediation. The best we can do, which I want to allude to what Segun said, is to have caucus with lawyers who have no idea as to what is expected of them. Call the lawyers to get it together and talk to them and ask them what contribution, and give them a small lecture without them knowing you are giving them a lecture of what is expected of them. The major thing expected of them is to encourage their clients to keep on talking and to keep on negotiating. It is not a matter of my rights, your right. It should be more of what is in my best interest at this point in time, ego aside. So the lawyers play a good role, a major role in mediation, if mediators will allow them. And how do we get to that point? Is to encourage our mediators, train them not to lose confidence in having lawyers in the mediation room. All you need to do, if you know you are having a problem with a lawyer, have a private meeting with the lawyers. Let them talk to you. Let them feel part of the process. That way, life will be easy. So it's training of mediators, rush to settlement, and I encourage mediators to also continue to have private caucusing with their lawyers. Sometimes the mediators are young, and then when the senior advocate comes in, they are agitated. So these are the things. And then some senior lawyers come in and see that the mediator is a young lawyer. They try to bamboozle them, you know, that kind of thing. But the mediation should also be trained. Keep your cool. Focus on encouraging the parties to talk. do not discourage lawyers from attending. Lawyers have a role to play to get to a faster settlement. Thank you.
Thank you so much, my lord. Loretta, can you please unmute yourself? And are you there? Loretta, could you unmute yourself? Okay, so I'm going to take, I think Iti Olatuji's hand is up. Iti, can you please unmute yourself and keep your feedback or comment very short? And I'm going to go to the question, and I'm going to go to the comment section and take the feedback and questions we have there. So over to you, Eunice.
Okay, good afternoon, my lord. Good afternoon, Fola and Leonard Silk. I was faced with a situation that I wanted to know because I'm a lawyer, I'm a litigation lawyer as well, so I do fight. But that particular time, I was the mediator in a session, and the normal introductory messages and all of that, the lawyer said he had never been in mediation session. So I tried to explain what mediation is and all of that. Then before we proceed, that they will have to sign an agreement to mediate because it's a voluntary process. And it was at that point, the party did not come for that defendant. And I asked the lawyer, hope we'll be able to get in touch with the party because it's party driven. He said, no problem. So I handed over the confidential agreement for them to sign and then the agreement to mediate. And the lawyer said he was not going to sign it. And I asked, he was asking for an adjournment. And I said, okay, I need to know whether you are submitting to mediation before we adjourn again, because it's not a corporate that will be adjourning and adjourning. And he said they want to participate, and that's why they have come. But you are saying you have not, you didn't sign the submission form and was not ready to sign the agreement to mediate. So at that point, I requested to speak with the party directly. The lawyer said, no, that I can't speak with the party. That he has to speak with the senior. He called the senior, and they were like, no, they are representing them. I tried to explain over and over that this is a party-driven process. So if you are taking an adjournment, I need to know that you will come or the party will come. And he went on and on.
So sorry I have to interject you. Can you please just keep the question short so I can know where you're going to?
So I want to have, at that point, should we just close the mediation or should we insist on still talking with the party?
Okay, do you want me to comment on that?
Oh, yes, my lord. Oh, yes, my lord. Yes, my lord.
Yes, my lord.
Yes, Eunice, what I just noticed from your story is that it may not apply to you. It may just be this very particular incident that you have. My experience has shown that many mediators arrogate unto themselves the power of a judicial officer. So if a lawyer says, I don't want to sign, you ought to find out why. Not to insist that why don't you want to sign? Why do you want adjournment? You know, that is another conflict that you need to deal with. So being antagonistic and insisting on them doing something formal will only break the relationship between you and that person further. If they don't want to sign today, you know, so you can't say you have to sign, you have to sign, you have to. The mediation was not starting immediately. Then what was the rush to sign that document? So sometimes let's not, we are mediators. If you are, what would I say? If you are kind of tough and insisting on formalities, you know, sometimes it backfires. So I think, you know, you may want to try to understand why is he not signing? You would even challenge him, and he challenged you to, we came here to explore settlement. Why do you think we don't want to? You know, so and now it's not a conflict between you and that lawyer that is developing. And then you wanted to bypass him and you made it clear to him, I want to talk to your clients immediately. So that's putting the lawyer in a very precarious, and yourself in a very precarious position, because you already declared war with the lawyer, and that will not go well for the mediation. So I'm not saying you should stop the mediation, but you may want to retrace your footsteps and deal with this issue in another way. There are sometimes I encourage mediators in a formal mediation setting, like a multi-door courthouse, things are done, because in an informal mediation, You don't say sign first, don't sign first, bring your issues, don't do this, do that, do that. You don't do that. So you need to make the parties feel at ease. If you really start and insist on these formalities, we are almost going back to litigation where formalities are the end day. So there must be a balance between what you insist on and what you don't want to. So that's my comment to that. So mediators should actually flow sometimes and not insist, you know. And then the point I said before, that mediators arrogate unto themselves judicial authority, you know, and then they even arrogate themselves this power, legal advice. They give legal advice. So that's why training is very important. So they mix all these things together, and then it complicates the system, and the lawyers see through them, and then they cannot boast that they are neutral. If you start giving legal advice or insisting, or, you know, things like that. So I think that's where so sometimes we should retrace ourselves. We should not rush to settlement. We should try and build confidence and build rapport first before the mediation itself will flow.
Okay, thank you so much, Milord.
That can take time. That can be difficult with some people because of their personalities. So, and you must understand that everybody is not the same. You must understand that. So you must be patient and allow the person have some confidence in you before you start insisting on certain things. Thank you.
Oh, thank you so much, Milord. So we're going to just we have so many questions, feedback in the comment room, and we'll just take it. Loretta, can you hear me now? Can you try to unmute? Okay, Loretta, can you hear me?
Yes, sir.
Okay, over to you.
Yes, I can hear you very well. Can you?
Yes,
right.
I can.
Good evening, everyone. My name is Loretta. All right. My name is Loretta Onwibia, and I am the executive assistant to Mr. Fola Alade here, founder of Fotefa Mediation Academy and principal of Fotefa Partners. Thank you so much, Milord. This has been such an insightful conversation. Thank you for being so honest and real with, you know, how you've been answering the questions. So I'll quickly go to the chat room now to take a question we have from Kamar Ogunye, I think, yes. So she's asking, my lord, is it legally feasible and practicable for the government to mandate some certain matters to go to ADR?
Milord, that's mandatory mediation. That's mandatory.
Yes, I don't know, because sometimes when you relate the question, it doesn't happen the way it really is.
Okay, Milord,
there are situations.
If I may, Milord, can I? Yeah, Milord, if I may I give a bit of more context to this question? Because I actually have a question there, so I'll just link both of them together. This for me falls within the ambit of mandatory mediation. Now, for someone like me, I accidentally stumbled upon mediation because the judge ordered that my case be referred to mediation. I'm sure if I had the option of choosing, I probably would not have wanted my case to go to mediation. Now, if we put the average Nigerian mentality into consideration, they like being forced to do something. And I keep using this analogy every now and then, that as far as mediation is concerned, I am not of the opinion that people should be forced to settle, but I strongly believe that people should be forced to go to the mediation. Then the option of settlement should now be left to them. So my question to you, my Lord, is this. What are your thoughts on mandatory mediation? Do you think mediation should be made mandatory?
Okay, so your question, and I don't know the lady who spoke before.
Yeah.
Her question was whether government can insist that certain matters be sent to mediation. It may be, for example, if there's an arbitration clause, it has to go to the ADR. If there's an arbitration clause, you can't go to court. You have to go to arbitration. Secondly, there may also be a provision for mediation before litigation in any agreement. And thirdly, there's nothing wrong in government telling its staff, see how you can settle this matter before going to litigation, or see how you can explore settlement before approaching the court or continuing to defend this case. There's nothing wrong. It just depends on how you communicate this request. So is it a question of forcing or a question of advising? Because even in court, judges are enjoined to persuade the parties to explore settlement. It's persuasion. And it depends on what the judges say and how they say it. In some jurisdictions, there's a provision during the pretrial conference. It is at that point, really, after you've done all the pleadings and all that, and then you ask, have you explored mediation? They have not thought about it. And then I know some judges will just go ahead, fix a date for trial. Other judges will say, why have you not explored mediation? If you find a lawyer that is very against ADR, you may want to refer that lawyer to the provisions of the professional rules of professional conduct. What I do, if I see that the lawyer is very difficult and is not understanding the need to explore, not to settle like you said, to explore settlement, I refer to the rules of professional conduct, not just the provision, I also refer to the consequences of not doing that. Then if they are still difficult, I keep on telling them the disadvantages of continuing litigation. I said that, so this takes 10, 15 minutes. And I say, all I want you to do is to explore. You know I'm here. I'm here. As they say in Delta, oh, I know they go transfer, they wait to now. If you don't settle, come back to me. So at that point, they start thinking about the conflict in a different way. You don't have to settle, just go and explore it. And there's an advantage, many advantages of exploring it. So mandatory mediation, it depends on what you mean. In Lagos State, they call it mandatory mediation. What they mean is mandatory exploration of mediation. Because if you go to the mediation ADR judge, you don't have to settle, but you've explored it. You don't have to sign a settlement agreement. Or if you don't settle, you still have to go to litigation. So you cannot force people to agree, to settle, but you can persuade them to explore settlement. I don't know if I've been able to expatiate on what the two issues are about.
Yes. Yes, you have, my lord. Thank you so much.
So for example, you have an attorney general who is ADR compliant. Number one, that attorney general will want all matters go to ADR. Two, all agreements, there must be an ADR clause. So if you so that happens, and then he tells all his staff, look, ADR all the time. I don't want any litigation. As you would expect, governments are not very good in litigation anyway. So it's in their best interest, especially for public purpose, to settle these matters privately and out of court. So I am not surprised that a governor will say, try and settle. You would recall, I noticed in the last 10 years, when judges have been appointed, every speech of a governor in swearing in a judge, every speech I have listened to, they have spoken about ADR. Every governor who has sworn in a judge in the last 10 years, I've listened to your speech, they will say, look for ways to settle matters out of court. They always say it. So there's nothing wrong in a governor insisting that we should be looking that way, you know. And then if you have an attorney general who toes the same line, then we are home and dry. Thank you.
Yes. Thank you very much, my lord. Before I go on, I'd like to acknowledge the presence of Honourable Justice Mary Isueli. Thank you so much, my lord, for joining us this evening. We are honored to have you in our midst. Then I also want to quickly take this comment from Precious Onabuchi. She says,
sorry about that. Please, a little bit about Mary Isueli. You should tell us.
Oh.
Okay, she's actually the Honourable Justice of, I think, of Edo. I think she's here. Of Edo High Court, yes.
She set up the Delta State Multi-door Courthouse.
Yes, wow. Yes, Milord, are you here with us? I noticed you've been in and out. I don't know whether it's a network problem. If you can hear me, Milord, can you please unmute yourself? Honourable Justice Mary Isueli. If you can hear. Yeah, she's got it. I noticed she's been trying to come in and come out, come in and come out. Yeah. Okay, yeah.
Sorry, so, Loretta, sorry.
So please continue.
So all right, sir. Some mediators do not allow, this is from Precious Onabuchi. She says, some mediators do not allow lawyers to engage in mediation because they believe lawyers compound the process. And she thinks this is as a result of personality clash between lawyers and mediators. Her hand is up. She would like to ask a question as well. So this is just her comment. Precious, if you can hear me, kindly unmute yourself and go ahead and ask your question. Thank you. After you, I will take Oreoluwa Ajewole, and I see another hand up. Okay, the hand has gone down already. All right. So Precious, can you unmute yourself? You can go ahead.
Good evening, everyone. Can you hear me?
Yes, we
I
can.
hear you.
Thank you very much. Good evening, my lord. Good evening, Fola Alade. Good evening, Leles Kid, and everyone on this platform. I really appreciate the practical perspective with which every matter here has been looked into. I'm a second-year law student, and during the process of this session, my lord had said something about ignorance being one of the clogs in the wheels of exploration of mediation by lawyers. And I was going to ask, could a foundational inclusion of training on mediation processes in legal education in Nigeria be feasible? And how well would it resolve this problem?
Do you want me to answer that?
Yes, my lord. Yes, my lord. My lord, every question here is directed at you, my lord. You are the one on the hot seat, my lord.
See. Okay.
Not me. Okay, over to you, my lord.
Yes, I think the question is, can mediation be part of the curriculum in legal training, right? Was that the question? So Precious, you say you are in year 2, so maybe that's why you've not met any training on mediation. By the time you get to the law school, I think some universities do some courses in ADR before you even get to law school. But at the law school, you do a little bit of that. It's not a major course in the law school as at when I was there, but it depends on your interest. If you are interested in ADR, you can take courses even while you are in the university during your holidays. I know that many institutions, they give training to law students even while they are in university or in law school. And then coming to webinars like this, it helps to also build your knowledge about mediation. So I think mediation, ADR, is part of the curriculum towards your final years and also in the law school. So you will get to meet such training.
Okay. Thank you so much, Milord. So, Milord, I have another table-shaking question to ask you, Milord. Is mediation justice? Now, I keep asking this question. I've asked mediators, I've asked litigators, but this is the first time I'll be asking a sitting judge because, and I'll give a bit of more context to this. Milord, an applicant files, a claimant files an action against a defendant, probably for breach of contract and all of that. Now, because he believes that he or she is being owed money. Now, at the end of the day, of course, we know that delay favors the defendant more often than not. Now, the defendant is now being made to concede to some certain things he or she would naturally not concede to because of the issue of time, congestion, amongst all other things. Now, if we now juxtapose that with the concept of justice, which Milord epitomizes and personalizes, what then would we now say mediation is justice? I would like to understand your own definition of justice vis-a-vis mediation, and let's see whether there's a way of harmonizing those two, Milord. Is mediation justice?
Okay. Yeah, I think you've answered the question by some of the words you use. A litigant is made to concede. If you make somebody concede, that is not, the person is not happy. So the conflict is not resolved. And that's what litigation does. The litigation does not make you concede. It actually forces you to concede. But mediation is supposed to be the opposite, to allow you to negotiate what you want. You see, that's why, again, I go back to training of mediators. If you have this idea from the very beginning, if you have an idea of what the person should concede to, you find yourself as a mediator pushing the person towards that settlement that you have in your head should be, without allowing the person to voice out his problems. At the end of the day, the person may actually agree to those terms. But if the person does not have an opportunity to voice his feeling about the conflict, he may think that that settlement was forced on him because he had not had time to consider it as a fair settlement to his grievance. So I doubt if a mediator makes a person concede, that cannot be a mediation. You cannot make somebody concede. It is the person's lawyer who should persuade his client by telling him the advantages of one term of settlement from the other. By telling him, if you take this offer now, it's better than us going to court. If you forget about all this interest, it will still save you money, because if we go to court, the case will last 10 years and you will be paying. Let's calculate how much interest are you claiming. Your total interest is 2 million. So if they are offering you the principal sum without the interest, let's see how much it will cost us to continue to go to court. So you don't even, the lawyer doesn't even make his client concede. He persuades his client to accept an offer. So mediator should never ever think of making anybody concede. Why? That's not mediation. As far as I'm concerned, that's not mediation. See, CEDR teaches mediators to pass through phases. There is the initial speech, then at a point you allow them to keep on negotiating, and then you explore. If those stages are not passed through, I'm biased because I'm a CEDR trained mediator. If you don't pass through those well-defined stages, your settlement may still be another conflict. So I'm not saying you must do CEDR, but there are stages. Some litigants or some parties will force you to move to the next stage quickly. Some will keep you at one stage for days. You have to be patient. Always carry Panadol in your handbag.
So thank you so much, Milord. Now, Milord, it seems like the face of modern litigation is changing now. No thanks to COVID. COVID has disrupted a lot of things and has forced us into this new reality. So my question to you, Milord, is this: where do you see core litigation practice and mediation in another 5 years? If you had the opportunity of having a look at a looking glass, how do you see mediation and core litigation practice in another 5 years?
I can only talk about my desire. My desire is that lawyers should appreciate more what ADR is bringing to the table. And they can only do so by training. We have to train the lawyers to understand that they can still make money. They can still practice law. Negotiation is part of practicing law. It's not by standing in court and amending a process 10 times. That does not make you a good lawyer. So my desire is that sooner than later, lawyers appreciate ADR rule. And even without filing cases in court, call the lawyer on the other side and say, yeah, I'm preparing to file a case in court, but is this something that we can settle? That's just a question. I hear cases in court. When I ask them, have you explored settlement? One party will say, the other side has not called me. I mean, there's no law that says one side must call you. You can call. I mean, it doesn't mean defendant must call the claimant. Because if you insist that defendant must call you, that means you are thinking that the defendant has no defense. Anybody can call. It doesn't have to be the defendant. So the future, I hope there should be more training of lawyers, of mediators. I'm sorry to say we're already there as judges, but lawyers are not there yet. Mediators are almost there.
So Milord, yes, ma'am. There's a general theme that runs through everything you have been saying since we started. Training. Is this deliberate, Milord? In everything, it's always been about you saying training, learning, we're learning, training, we're learning. I would like to hear more on this, Milord.
I don't know if I've had opportunity. I mean, I've attended some of your webinars, and I have learned, even though I've been an ADRO practitioner for nearly 25 years, every time I listen to your webinar, I learn something. That's what I mean by training. It doesn't have to be formalized. Attending things like this, you learn, you gain experience from it. So it's not like a formal training. You can even read articles. All that is part of training. You can learn from other people's opinion. You can read books. You can listen to Fola. You can listen to Harriman. All that is training. It doesn't have to be something you pay for. Although if you pay for it, you will tend to be a better professional. Because those who teach you, apart from knowing having the knowledge, they also know the skills that you need to learn to be able to practice properly. So mediation is not something you just jump into. And then when you get there, you say he's owing you 1,000. Can't you pay 500? That's not mediation. That's not mediation. As I know it, as I know it. So we don't want a situation where people are made to concede and they go home unhappy. I've seen cases where even settlement agreements are being challenged in court to be set aside. I've seen cases where lawyers write petitions against mediators. I've seen cases where lawyers come to court and report mediators to the judge. So, and that is because of a mediator must be patient. You may not have all the time in the world, but you need to be patient because there are different kinds of people. You must be able to understand the kinds of people in front of you, the parties, as well as their counsel. You must understand their chemistry and flow along. If it's a tough person, you need to break down those barriers before you can have a successful mediation.
Wow.
So I mean training, I mean attending even free conferences like this.
Okay then. Thank you so much, my lord. Loretta, I believe you have a question or feedback from the comments. Over to you.
Yes, I do. I do, sir. Can you hear me, sir?
Yes, you can. Please proceed. Thank you.
Thank you, my lord, for your answer to that question. You really hit the nail on the head. Someone raised a virtual hand in the chat room. Oluwa Ajewale, would you still like to ask your question? You can unmute yourself now and ask. If not, there's another question from Daibo Toyo that I would like to take.
Please proceed.
Please, Oluwa, are you okay?
No, just continue.
Okay. Daibo Toyo is asking me, Lord, that please, does the mediator or the multi-door courthouse have any role to play in enforcing settlement agreements, especially when a party defaults on the terms of the settlement agreement?
Yes, my answer to that is two. If the agreement is outside the multi-door, it's a different
Milord, I don't know whether you can hear us, Milord.
I can hear you.
Okay, yes.
The question was, can the multi-door courthouse enforce agreements? So there are two agreements the person is referring to. Settlement agreements from the multi-door courthouse and other agreements. I will take the issue of the multi-door courthouse agreements. As you would know, the multi-door courthouse is an attachment of the High Court, and it's court connected. And the reason for that is for the High Court to use its enforcement powers to enforce agreement made at the multi-door courthouse. So automatically, any agreement made at the multi-door courthouse is liable to be enforced by the bailiff of the High Court if it is not adhered to. Okay. Agreements made outside can be brought to the multi-door courthouse for an ADRO judge to endorse it. It becomes a judgment of the High Court. Other agreements can now become a contract, which will now be a cause of action in a High Court for enforcement. So if you have an agreement, a settlement agreement outside the multi-door and outside the court, that settlement agreement has become a contract, which you can now file an action to enforce that contract in the High Court. So these are the three different ways you can enforce an agreement. Yes, agreement for multi-door courthouses are liable to be enforced by the High Court bailiffs. Other agreements, you need to file an action for enforcement.
Okay. Thank you so much.
I don't know if I've answered the question.
Oh yes, my lord.
we do.
Yeah, I've unmuted Oreoluwa, Loretta. Oreoluwa, can you please let's take your question. Very short, please.
Okay, thank you very much, Mr. Fola.
Okay
Thank you a
then.
lot for showing up and giving us all the things that you've been saying. Actually, Milord actually answered one of the questions I wanted to ask you this last the last thing. And then the only other question I really want to ask you is concerning when Milord was saying talking about mediators being giving legal advice, actually giving legal advice. My question is this: is there a thin line? What's the thin line between a mediator showing parties their plethora opportunities of their power to negotiate, which probably include their legal stance and actually giving an outside legal advice? I don't know if I
Okay.
this right.
Milord, I don't know. Yeah, I don't know whether he heard it. He said he wants to know what the thin line is between a mediator advising parties on encouraging parties to negotiate, and also advising parties on the fact that there are plethora of ways of resolving their disputes. And that stems, yeah. I don't know whether that.
Okay, if that's the question, the mediator advising parties to negotiate. That's one of the roles of the mediator, to encourage parties to negotiate. I mean, there are ways. It's a skill you learn, and it's born out by your communication. The parties will just go into negotiation. Sometimes the parties even start negotiation from the very first day they come in front of you. Some will just say, if only he apologized. He's already giving you a sample of what he wants. So you just key into that and say, so are you saying that apology is one of your demands? He said, yes. He was too proud to apologize. If only apologize, I will forget about all these claims. So that party has already moved you down the line. No long stories. There's already something on the table to work on. So the job of a mediator is to use these mediation skills to encourage the parties to negotiate. Without negotiation, you can't reach an agreement. And that's the problem we have with many mediation settlements. You don't allow the persons to negotiate because of the way you communicate with the parties. Negotiation is a big part. As you can see, what is mediation? It's a negotiated settlement. So negotiation is a big part. So we must learn the skills to move the parties to come to a negotiation table. The second question, whether a mediator can advise on what?
What I mean, can advise parties on plethora of opportunities available to them to settle.
That's a big problem. In the sense, I see it as a big problem in the sense that there seems to be some confusion as to the role of the mediator. So when we're talking about mediators, we are not talking about advising them about other roles. In a multi-door courthouse, because it's a formal institution, you have dispute resolution officers who may, depending on how you approach the multi-door courthouse, tell you which of the doors, multi-door, which of the doors best suit your purpose. So you may be arbitration, mediation, and all of that. So, but once you are taking the role of a mediator, you have no business with advising the client as to, arbitration would have been better for you, or early neutral. I mean, you have no business doing that. All you need to do is to exhibit skills to assist the parties to negotiate. So that means, from what I can see, we as mediators, we are trying to build in so many roles when we are mediating. We are building the role of a judicial officer in the mediation. We are building the role of a lawyer, giving legal advice as well as giving advice on ADR alternatives. A lawyer can do all that. But once you say you are a mediator, you just have to keep to the mediation rules and your ethics and skills. So let's not confuse being a lawyer with being a mediator, being an arbitrator, a dispute resolution officer who has the leeway to advise or to make it possible. I mean, a dispute resolution officer should be able to look at an agreement and say, you have an arbitration clause here. We have arbitrators in the multi-door courthouse. So I will refer you to the exact door that suits your purpose.
Thank you so much.
I don't know if it's a little bit confusing what I read. I don't know. Does it answer your question?
Yeah, I believe so, my lord. So Loretta, there's another question in the comment section. I'll let you bail the cat in the chat room. Yeah, I'll let you bail the cat on this one. So if my lord now holds you for contempt, it will be you and not me. So
Hey.
okay, ask the question.
Milord, there is an interesting question in the chat room from Kamar Uguneye. She said, due to the busy work schedule of judges, is it appropriate for judges to be mediators? What would you say to that, Milord?
It is not.
Wow.
You have to give more context on that, Milord.
I use Lagos State as an example. An ADRO judge tries to look at the case of parties and encourages them to settle. And this is done because we don't want a situation where the judge moves from the arena of a judicial officer into too much persuading parties to resolve. So there's a thin line, actually. Though the sitting judge will not mediate, all you need to do is to encourage mediation. You can, if you mediate in a case, you cannot handle that case anymore.
Yes.
But in some jurisdictions, they appoint ADRO judges who sign settlement agreements to make them enforceable by the High Court. So that is different from that judge mediating, because if there are sometimes a judge is a human being, we may get carried away and start saying, but what if you forget about the interest? How would that, when you make such comments, then maybe you may think about it. Oh, I've said too much. I can no longer hear this matter. So, but really, a sitting judge should not mediate a case before it. That does not mean that an ADRO judge cannot conduct mediation outside, pro bono. It's purely pro bono, outside the proceedings before it.
But my lord, there's some sort of mediation even during the trial. I don't know whether they still do it, because I'm actually losing touch with litigation. Pre-trial conference. Some schools of thought believe that pre-trial conference is some sort of mediation, wherein the judge is not seated he comes down to the arena to have some sort of discussion with parties. So what is the distinction between pre-trial conference and mediation, so to say, premised on what you just explained now, my lord?
Yes. And first of all, we must now go back to look at the reasons why we have pre-trial conference. There are certain things that you need to discuss during a pre-trial conference, because it's not litigation wholesale. Some judges don't robe, they don't sit on the bench, they go down.
Exactly, not.
But all they do with regards to settlement is to encourage mediation, not that they will conduct the mediation themselves. Because ADRO is just 1/10 of what happens during the pre-trial conference. During the pre-trial conference, all the pleadings are settled. We know the active pleadings, we know the documents that are to be tendered. So there are so many things you discuss during pre-trial. The ADRO is just one out of maybe 10 or 15 points. And during that ADRO session, all you need to do is, have you tried to resolve? No. I go further to ask, why have you not? Some will say, now he has never come to my office, or I live in Abuja. And then I go ahead and say, well, you can do these things by telephone. You can do it by Zoom. And then the more I say that, the more they start thinking, oh yes, though, we should really explore. And I say, we'll fix 2 months time for trial. So you have an opportunity now to go and negotiate the conflict and come back to me for the trial of the case. So that's what happens during the pre-trial. As the name implies, it's a pre-trial settlement of issues. It's not purely ADRO. ADRO is just one aspect of so many things that happens during the pre-trial. I mean, that's my I don't know what happens in other jurisdictions, but a sitting judge does not do mediation when a case is happening. Because you would have, a mediation is supposed to be confidential. You should be open to say anything you like. And if you say it, what if there's no settlement? And then the judge hears the case again? I mean, it won't be right.
Okay, Milord. So, Milord, we have another interesting conversation, and I just told Loretta to unmute herself, and I'll give a bit of context into this. Loretta, I met Loretta when she was in school, year 4. She displayed passion for mediation, and somehow, some way, I've actually been able to mentor young people on mediation, because I believe in catching them young and molding them in line with mediation. But there's always a question that always comes up, and she always asks me that question, that there seems to be some sort of disconnect between older mediators and young and upcoming mediators, and that it seems as if mediation is ascribed to a particular age group of some sort. Mm-hmm. So when they are coming up, they find it a bit difficult for them to even come into the mediation circle. So, Loretta, I would like you to unmute yourself and give more context to that question, so that we can hear from Milord on what he has to say.
All right, so thank you very much for bringing that up, because Milord mentioned something about young lawyers when they see maybe a senior advocate coming to represent a party at mediation and they start to get intimidated. And I was like, yes, this is, she must have witnessed something like this before. And this is something that I also find a bit challenging with the mediation. When parties come in and they see an older mediator, they give that mediator some sort of respect. But when they come and see a younger mediator, they may say, who is this one? I can give birth to you. You are not older than my last born, and say things like that. So for young mediators, it's a bit difficult to really picture ourselves as mediators, helping parties resolve disputes, even with all the passion and everything. There is a perception the parties will have of us. So I don't know if Milord has any sort of advice, maybe how younger mediators can carry themselves or assert some sort of, authority in a way when, mediating during a mediation session.
I'm sorry, Milord. I also fall among the younger mediators she's talking about, my lord. Because Milord, and I say this because
because you have experience, you have had so much experience that I don't think any senior lawyer can bamboozle you in it.
No, but that's the point, Milord. My only saving grace really is my qualifications and the fact that usually when I want to start sessions.
You've answered my question. I go back to training, developing your skills. If you start exhibiting those skills at first contact, they will not look at your age. And looking down on people because of their age is not peculiar to mediation. It's even peculiar to judges. Newly appointed judges, you will see senior advocates coming and shouting in court. So, and if you go to a hospital and you go into the doctor's room and you see a 22-year-old doctor, your first impression is just, will she, so it's not peculiar. Age sometimes is good. Young age is good for certain things. Like if you want employment in a bank now, they'll prefer the younger person. But when you approach somebody that will determine your interest, you feel older people have more experience. And then you tend to look down. And because the young mediator knows that, then you have to go out of your way to build rapport. Building rapport is very important. I use the doctor as an example. You enter a doctor's office, a 22-year-old girl. Your first impression, does she know how to do this? Does she know how to do that? But after a while, if you want to go to that hospital, it's that same lady you start asking for because she has exhibited some form of professionalism, which you even prefer. Then you start seeing old people as if they don't even know the new things about medicine. So nobody can help the young mediator out of this problem. It's only you that can help yourself. And it all boils down to building rapport from the very first point of contact. With anybody, you don't know whether they are going to bring old lawyers or young lawyers. Even young lawyers, they look down on young mediators, not just old lawyers. So the impression is that they want to control you. I've told you, they even want to control young judges. So it's a natural thing, and it's a thing among Nigerians. We have no respect for anybody. You know, abroad, people respect their cleaners. They respect their anybody. But here, except you are in a high authority, nobody respects you. So it's a common thing. So we can overcome that by exhibiting good mediation skills from the very beginning. And the first thing is rapport, building rapport. So how do you build rapport? You will learn how to build rapport if it doesn't come to you naturally by going through training. This thing is not a mediation, it may not come to you naturally. There are certain skills. You may have a natural talent to want to make people settle, but there are certain skills you must learn in addition. So building rapport, improving your communication skills, most importantly, your non-verbal communication is very, okay, I'll give you an example. You are in your office as a mediator, you have a mediation meeting, and then they come into your office, the lawyer and his clients, and they enter. Good afternoon, they say, good afternoon, Loretta. Then you are writing something, you don't raise up your head. Good afternoon, please sit down. You've already spoiled the relationship. Take the other example. As soon as they get to your door, before they knock on your door, you stand up to go and welcome them at the door. How are you? Well done, sir. Please come and sit down. That's the difference. That's the difference. Or if you want to pose as a judicial officer, as if you are the one to determine their rights and obligations, they will attack you back. And you won't get anywhere. So those little things about communication is a major thing that can build rapport, non-verbal communication. You see a lawyer looking at his clock during the mediation, and you ask, do you have another appointment? Would you want us to postpone? Then he says, no, I'm sorry. But you've shown concern. That's building rapport. Or like this, or the lawyer stands up and say, I didn't know it would take so long, go, please. And he stands up, I want to go. And then you say, no, we must continue. You've spoiled the rapport. So little things like that, you don't learn except through experience.
Milord, it's interesting. Milord, I'm sorry to interject. It's interesting that all what you are saying, they fall within the ambit of emotional intelligence. I don't know whether it is deliberate or accidental, Milord. All these points you are talking about.
I didn't do any course on emotional intelligence.
Wow,
CEDR training will teach you this. Communication skills is very important. And then I've learned it from experience. When you smile at somebody, it makes a lot of difference. It breaks down all the barriers. But if you order, especially in Nigeria where we have serious egos, order somebody to do something. So why? Only judge orders. So mediators must try not to play the role of lawyers, not to play the role of judicial officers. Many of them do play the role of judicial officers, I must tell you. And it's a shame. They get away with it sometimes, but that's not being a mediator.
So, but Milord, so in the defense, in the defense of us lawyers, would it be safe to say that lawyers they do what they have with what they know, and that if they know better, they would act better? Because these are things that we were never taught in law school. We were just taught advocacy, we were taught adversarial nature. So the idea of all these little soft skills that are coming into play are things that we never tuned our mind to. And I think a lot of the things you've said has to do more with us lawyers, not necessarily even learning some things, but unlearning and relearning a lot of what we have been taught in law school. I don't know what your thoughts on this are, my lord.
Yeah, you are right. But you see, I think here we're talking about being a mediator.
Yes, being a mediator, yes, ma'am.
If you went through CEDR training, communication skills is a major part of any mediation training. Without developing good communication skills, you cannot be a good mediator. And the communication skills I'm talking about is 95% non-verbal, not written. I mean, oral can be the tone of your voice. Tone of your voice is non-verbal. So I think we should concentrate. I think Shegun does a lot of training in this area. He's a communication skills expert. So if we want to be good mediators and successful, we must take communication skills, especially non-verbal communication, very important, because that's what destroys relationships. Imagine a husband comes home from work and the wife opens the door, and as soon as she opens the door, she turns her back on him and walks away to her bedroom to continue with a phone call. She hasn't said anything, but what is the interpretation of her behavior? So we must know what good non-verbal communication is and what fatal and negative non-verbal communication is. That's the only way we can cross all these barriers, all these problems. That's the only way. That's the only way.
Wow. Thank you so much, Milord. So, Milord, as we round up, Loretta, do you have any question before I take the last two questions for Milord?
Yes, I got a question sent to me privately by Benjamin Fatogmu. He says, I don't know if we still have time to take it, but I'll quickly run through the question.
Yeah, please be fast.
One of the reasons why lawyers have difficulty with regarding mediation is when it comes to the appointment of senior advocates of Nigeria. He said lawyers see mediation as not counting when it comes to SAN appointment. So how do we get out of this with lawyers?
Milord, that's another table shaking question. Yeah, Milord, that's another silk and mediation.
Yes, I agree with them, but then I always like to work with data. How many of their cases are taken to mediation that ignoring those prevented them from being appointed senior advocates? I don't know whether you understand what I'm saying.
I do.
How many, there must be some data that out of the 10 cases I had this year, 9 were settled by mediation. That is why I'm not able to get SAN. There's no data like that. People just want easiest way out. It's the same thing for judges. The initial reaction from judges was that, why, if we encourage parties to settle out of court, why can't we put that in our returns? That we did this encouragement. That's why people settle. Up to today, that question is still unanswered. So, but that has not prevented judges from encouraging people to settle out of court. Although they would prefer for it to be noted as part of their returns that they did this and they did that and they did that. So, but to me, it's such a negligible thing that it's not something people should cry about. So the cases that the advocates take to mediation is so negligible compared to what is required of them to become senior advocates. Okay, let's say mediation, that is different. I don't know, there was some noise being made about lawyers who conduct arbitration, because it's a form of advocacy. I don't know whether that is being considered as well. I have a feeling it's being considered that if you are a lawyer in an arbitration, it's almost like litigation, it's private litigation. So you would have exhibited some advocacy skills, which Senior Advocates of Nigeria is all about. If you are a lawyer in arbitration, you would have exhibited advocacy skills. So that should be considered when you are being considered for the as a Senior Advocate of Nigeria. So I don't know that they are considering that. But I can see that from the academic session, a lot of professors and staff are being considered. So, but the struggle continues.
Thank you so much, Milord. So, Milord, as we round up, I'm going to take one question, but for 4 different players in this industry. First of all, my Lord, what advice do you have for lawyers who want to embrace mediation as a profession? I don't know, what advice do you have for them?
For now, as you need to go through training, because I don't know, I'm not scared of using the word training. You need to learn the skills. You need to expose yourself. You must acquire the skills. After acquiring the knowledge and the skills, you must be a good administrator, because if you want to set up as a mediator, it's a business. So you must have business skills. So these three things must be something you have to look at: knowledge, skills, and business acumen. You must have a proper office, you must have rooms, you must have privacy, you must, okay. So your legal knowledge is just in the background, but you must train to improve your knowledge and skills with regards to mediation. And if you are successful in many, if people are happy, they will recommend you to others, just like the legal profession. So that's what many lawyers too don't know. If you handle somebody's case and it's still 10 years in the high court, will that person recommend another person to you? And a legal practice is almost like a court. The clients are grumbling, but they are unable to do anything about it. They never expected that their cases will remain 10 years in court. They are in court 5 years, the judge is transferred, they start de novo. Before they know it again, the judge is transferred. Their pleadings have been amended 20 times by their lawyers, and they don't seem to understand. That was not the plan. So to be a mediator too, you must have the skills and the knowledge. You must be a good businessman. You must know that if you treat one person well, the person will recommend you to others. So there's nothing wrong in establishing yourself as a mediator.
Thank you.
But I would say for now, combine it with litigation. Don't just go out there and say.
Yes, ma'am. Therefore, the mediators in active mediation.
If you are well known in the field, other lawyers will appoint you as mediators, even when the court refers them to mediation. They may prefer to come to you than go to the multi-door courthouse. Litigants have an option. No? You don't have to go to the multi-door courthouse. You can settle your dispute with private mediators. So it doesn't have. So if they feel more comfortable with private mediators, they won't go to the multi-door courthouse because it's a choice. It's not mandatory to go to the multi-door courthouse. Thank you.
For the mediators in actual mediation practice, then what advice do you have for them? First we had lawyers and the mediators themselves.
Yes, we have gone through a list of some of the problems we have with mediators. And then maybe you want me to repeat them again. It's the approach. And that approach is based on lack of acquisition of skills and knowledge. Do we know our roles as mediators? What are we expected to do? If what we are expected to do, we're not living up to that, we can acquire that by further training. And as I said before, training does not mean paying. You can read books, articles, attend webinars like this. You gain a lot from it. And that way you improve yourself. That's the only advice. Improve, improve, improve. And it's difficult. I don't know whether, like I told you before, a mechanical engineer introduced me to mediation, not a lawyer. And he's a very good mediator. So it's not a prerequisite that you must be a lawyer before you can be a good mediator. But being a lawyer may assist you in doing reality testing, which at the end of the day, you can do reality because of your basic knowledge of the law. But it's not a prerequisite to being a good mediator, being a lawyer. Not. What should be in your mind is, how can I encourage these people to settle their disputes? What can I say? What can I do? You are not to exhibit your lawyer skills there. No, only encouragement to negotiate. So nothing to do with law at all. It's ability to persuade people to negotiate. That's the major role of a mediator. So, and you can only acquire that by focusing on this one major skills, improving your communication skills, and really know what you are trying to do. You are not trying to be a judicial officer. Neither are you trying to be a lawyer. You are trying to assist. That's the definition of a mediator, to assist parties to arrive at a negotiated settlement. Assist.
Thank you so much, my lord. Then last but not least, my lord, because we have a cross section of end users here. Some of them are curious about mediation. Some of them want to incorporate mediation into their businesses. Some of them just want to know what mediation really is all about. What advice do you have for them, Lord? The end users, parties, and clients.
Mediation has come about because, one, there is no society that you don't have conflicts. In business, in your personal life, in your environment, there's always conflicts because people's understanding of issues are different. So there must always be a conflict. For end users, there are 3 stages: to prevent the conflict, to tackle it immediately it rears its head, and then to try to resolve it. To prevent it is to learn better communication skills. The example they always give, if 2 people are working in the same office, somebody goes to the kitchenette, drinks coffee, and leaves her cup there, doesn't wash her cup, and then you tell the colleague, make you dey wash your cup now. Or you tell her, why you dey leave your cup there every day, you know they wash them? 2 ways of asking the same question. So somebody is being irritated by that cup not being washed. If that issue is not taken care of, it will develop into a conflict. If that conflict is not taken care of, it will develop into a crisis. So usually it's better to prevent a conflict by using good communication skills, especially non-verbal, and understanding. So the mediation has become important because of the disadvantages of litigation. There's majorly not much advantage in litigation. The only advantage you can get in litigation is to stop people who are trampling on your rights immediately. For example, injunction. That you may not be able to get through. So if somebody is destroying your house or doing something, you need quick access to somebody that will resolve or put that on hold. That is a major advantage of litigation. Outside that, some people also use litigation as a means to pull the other party to a negotiation table. That is fine. So apart from that, really, there's not much advantage. I'm sorry to say, as a judge, not much advantage.
That's the word, as a judge. But this is one of the most mind-blowing sessions I've had, my lord. You have
the process will make you sick. It will ask the non-lawyers now. Are they happy? Even the lawyers themselves. It's just that it's a profession you have to work for money. You have to think what cross-examination questions. Things are easier now that you prepare your case before going to court. In those days when we were in practice, you don't even know what the other side is thinking. On your feet, you start developing questions. And it causes a lot of tension on your body. So I don't know. So the non-mediators here, I encourage you to improve your communication skills in your establishment, deal with conflicts as soon as they arise, forming crisis. Even if you have a conflict, there's nothing that stops you from approaching a mediator instead of going to court. You don't have to go to court first. There's nothing that says you must take your conflict to court first. You can approach a mediator. You can also approach the multi-door courthouse, which they call walking cases. So you don't have to go to litigation. And then when you go to your lawyer, if you have to, if the lawyer does not suggest ADRO to you, ask questions about ADRO. Because you've attended this conference, you are at liberty to ask your lawyer, I heard there's something called mediation. How about that? You ask. Thank you.
Wow. My lord, I am simply blown away. Before I say anything, Loretta, please, first of all, my breath. I would have caught my breath. Loretta, over to you.
Okay, sir. Do I go ahead with
Loretta,
the
are you
vote of
there?
thanks? I have unmuted
Yes,
myself,
please.
sir. Can you hear me, sir? Okay. Okay, sir. So do I go ahead with the vote of thanks?
Yes, I can hear you. Please continue.
Okay. Okay. Thank you so much,
Yes,
my lord,
please.
for this very interesting and insightful discussion. Thank you for sharing practical tips and advice that we all can take back and incorporate into our respective mediation practice. Thank you for your 100% honesty. I mean, you said it the way it is, and you constantly hit the nail on the head. So thank you so much for that, my lord. I'd also like to especially thank everyone that joined today's session, that came in very early and that has stayed through till now. Thank you very much. Our goal at Potefa Mediation Academy is to ensure that you have everything you need to, build a thriving and profitable mediation practice. But at the end of the day, we can't do it without your support and your commitment to attending webinars and sessions that we put together like this. So thank you so much to everyone for being here, for taking out the time to learn and engage with the Lord. Thank you very much. And there's going to be another session next week, Saturday. We hope to see you there. We'd love to have you once again. Thank you.
Yeah. Thank you so much, my Lord. To round this up, my Lord, I will thank you for the gift of your time. We thank you for the gift of your knowledge. My Lord, words fail me because it's not every day one gets to have a judge encouraging younger mediators like myself to do what we do. So, my Lord, may the good Lord continue to bless you for what you do and continue to be a shining light to everything as far as mediation is concerned, my Lord. We truly, truly appreciate this, my Lord. I don't know whether I have final words before I give one announcement, and we'll call it a day, my Lord.
Yes, I must also, which I should have done at the beginning, thank you for inviting me. I was very excited. I was very satisfied with listening to you every Saturday. But it seems to me that for some few Saturdays, nothing has happened. Is that correct? Or I didn't just get
yes, my Lord. No. Oh, yes, my Lord. We had to go back to the drawing board because we noticed we had been focusing too much on mediators, on the service providers. And we just, and at the end of the day, those that should be listening to us talk are the end users. Because we believe, and that was one of the reasons why we went back to the drawing board, that look, if there's going to be any change in mediation, it's not going to come from the lawyers. It's not going to come from mediators. It's going to come from the end users. Because you see, if we have the end users having disputes with each other and going to meet their lawyers and telling their lawyers that, you know what, I want to still maintain a business relationship with this person, but in maintaining that business relationship, I want XYZ. So we are of the opinion that if the end users demand mediation, the lawyers and mediators don't have it. They don't have a choice. They will definitely change their mindset. So what we decided to do is to now take mediation to the end users. So this will probably be the last session we'll be having with service providers. We are now going to go to the industries to now start bringing CEOs, bank MDs, heads of HR to have discussions with them and even get to have an understanding of why they are not seeing mediation for what it is. So that was what we had to go back to the drawing board to do. And we're also having a training coming up next month. I was going to say that, but since you asked, I would also talk about it. It's called Mediation and Emotional Intelligence, a Lawyer's Secret Code. So what we intend to do now is to not even go to the law firms, to now go and start preaching the gospel of mediation. Because we believe that if lawyers can change their mindset, because we've also noticed from the trail, because what we usually do is that after every session, we go back and we watch it. And we found out that a lot of times, the only reason why lawyers don't embrace mediation is because they don't even know how to use the tool of mediation. They don't know how to make money from mediation. They don't understand that the advocacy skill in mediation is not in the mediation session. It's pre-mediation. They don't understand the dynamics of the fact that if you really want to empower, you have to empower your client to resolve disputes on his own. You don't resolve disputes for your client. So these are the dynamics that took us back to the drawing board. So you have no idea how excited we are that we reached out to you, my Lord, and you answered us. Of course, this is like a good omen saying that look, we are on the right track to do what we do, my Lord. So that's what that's what happened quick.
I must encourage you to, now that you want to carry out evangelism, you may want to partner with the MBA, local branch.
Oh, yes.
Because once lawyers embrace it, the litigants may have no choice. Imagine an MD that you want to invite now. Once there's a problem in the industry, they don't think of mediators. It's a lawyer they first think of. So you must not just the MDs, the legal departments. The lawyers should be trained to look at ADR first rather than litigation. So it's the lawyers, because clients tend to believe in lawyers a lot. So I think more of the lawyers than on the litigants themselves. And you can partner with the MBA.
Oh, yes, my Lord.
Message so that we can all understand it. Thank you very much
yes, my lord.
for inviting me. I wish you the very best. Thank you. I must acknowledge some of my friends who are here. Mrs. Murphy Akpeyi, I can't see your face.
Yeah, I can see Mrs. Murphy, yes.
I can't see your face. Who else? Unamdi, my DG, Multi-door Courthouse. And a few, they've all gone. Okay. Thank you very much. Everybody is my friend. I can see Nkechi, yes. Thank you very much. Thank you. God bless you.
One more second. Yeah, 1 second, my lord. So for those that came in late, please, I would enjoy you to search for this on YouTube. We have the recording is on YouTube. This is one session you do not want to miss. So please go to YouTube and search for at Fortefa Mediation Academy. It's going to be titled the Synergy Series with Honourable Justice Roli Harriman. To watch this. For any mediator, any lawyer that wants to take up profession of mediation and is confused about a lot of things, this is one session you have to watch. And on this note, I want to thank everyone for tuning in. May Lord, most especially, man, thank you so much for the gift of your knowledge. Thank you so much for the gift of your time. And to come your way next week, Saturday, 5 p.m. prime time, with another interesting session of the Synergy Series. I wish everyone a lovely weekend ahead. Good night, everyone. My lord, thank you so much, my lord.
Thank you.
Yes, good night. Goodbye, everyone. Thank you.